Hello and welcome to part 2 of my lecture on judicial precedent. Here we will now look at judicial precedent and the role of judges. The doctrine of precedent works within the context of the court structure. The hierarchy of the courts provides the fundamental institutional structure for the practice of precedent. So now we will focus on two major concerns that have developed in relation to the institutional structure of precedent. First of all, the House of Lords, and we will refer primarily to the court as the House of Lords because the cases that we'll be looking at are directed by the House of Lords and not the Supreme Court. The first thing we will look at is the extent to which the House of Lords binds itself, or the extent to which the House of Lords can depart from its own previous rulings. The second major theme we will look at is the extent to which the Court of Appeal can, in exceptional circumstances, depart from the rulings of the House of Lords, and the extent to which it can depart from its own previous rulings. So continue with this theme, we're reminded of one of the primary concerns of the doctrine of precedent, and that is the hierarchy of the courts. The fact that inferior courts are bound by the superior courts in the hierarchy is vital to the operation precedent. If we were to start to mess about with this, then inevitably we will produce inconsistent results and decisions. Nobody will know what the law is. In order to achieve this, courts in the hierarchy for the most part have to follow their own previous rulings. If they depart from their own previous rulings, then again inconsistency may arise and inferior courts will not know how to develop the legal principles. What is the overriding issue that underpins this system? In short, it is one of justice. How justice requires for the most part that like cases are treated alike. This relates in practical terms to the hierarchy of the courts and that inferior courts must follow the superior court's previous rulings. It is, however, not inconceivable that to do justice in an instant case, in an individual case, in an exceptional case, that it might be necessary to depart from previous rules, previous principles. This concern is within the realms of philosophy. For the most part, what is needed to ensure justice is a consistent approach and adherence to rules. One could, however, almost make the argument that in exceptional circumstances, to be just, one has to depart from the rules. The instances when this has tended to occur take place generally at and around the level of the Court of Appeal. What is at stake is the extent to which the common law can develop flexibly and the amount of flexibility. This means that superior courts, again, may in certain circumstances have to depart from their own previous rulings if there is good reason to do so. It will give us some insight to look first at the House of Lords and a statement made by Lord Halsbury. This is from London Street Tramways Company Limited and London County Council. What Lord Halsbury is talking about in this case is effectively a vision of how the House of Lords should work, so let's take a minute to read his statement. Quotes, "Of course, I do not deny that cases of individual hardship may arise, and there may be a current of opinion in the profession that such and such a judgment was erroneous. But what is that occasional interference with what is perhaps abstract justice as compared with the inconvenience, the disastrous inconvenience of having each question subject to being re-argued and the dealings of mankind rendered doubtful by reason of different decisions, so that in truth and in fact there would be no real final court of appeal? My lords, interest re public, that there should be finis litium at some time, and there could be no finis litium if it were possible to suggest in each case that it might be re-argued, because it is not an ordinary case, whatever that may mean." So what is the point that Lord Halsbury is making here? On reading the statement, it should be obvious that what he is saying is that the House of Lords could not depart from its previous rulings, even if there is an opinion that a previous judgment, a ruling in a previous case, resulted in a ratio that was erroneous. He says this about it, but what is that occasional interference with what is perhaps abstract justice as compared with the inconvenience, the disastrous inconvenience of having each question subject to being re-argued? In other words, the fact that a case may have been wrongly decided is not the most important consideration. The most important consideration is that there is finality in the law, that a court should be empowered to make a final ruling, what he calls with a flourish finis litium. He writes off the other concerns as abstract justice. He also says towards the end of the quotation that the argument that a case is not ordinary, i.e. that it deserves different treatment, that there may be an argument for departing from a previous ruling, is an argument that he does not countenance, that he dismisses immediately. Now this is in keeping with a hierarchy of courts, that we should stick to previous judgments. But it does beg the question, what if the law contained a load of erroneous decisions, a load of incorrect decisions? Because what Lord Halsbury is saying, in other words, is it doesn't really matter if the law contains lots of incorrect decisions, provided that we have a final court making rulings. Surely, though, there should be a mechanism to make sure that these erroneous, incorrect decisions can be changed to allow the law to develop in a correct way. The point reflects back to flexibility. For the law to be able to change to changing economic or social circumstances, then, to some extent, we may have to allow a House of Lords / Supreme Court to overrule itself in exceptional circumstances. This now leads us to a fundamental document for the modern practice of the House of Lords and now the Supreme Court. The statement of Lord Halsbury comes from some time ago, but now we need to look at a more modern document, relatively more recent times. That is the practice statement of 1966, which defines, as we've been trying to define, the modern practice of the House of Lords. So let's look at some of the main ideas in the 1966 practice statement. Quote, "Their Lordships regard the use of precedent as an indispensable foundation upon which to decide what is the law and its application to individual cases. It provides at least some degree of certainty upon which individuals can rely in the conduct of their affairs, as well as a basis for orderly development of legal rules." It then continues, "Their Lordships nevertheless recognise that too rigid adherence to precedent may lead to injustice in a particular case, and also unduly restrict the proper development of the law." In part 3 of my lecture on judicial precedent, we shall look at when the Lordships are not going to adhere rigidly to precedent because it leads to an injustice. So if you're enjoying this lecture, please go on to part 3, and also if you'd like to contact me, then my email address here is in the link, and so it's a domain name for my website. Thank you for viewing, and it would be great if you could subscribe to my channel.